SJC-12462, John Doe number 76819, and others, v. Sex Offender Registry Board.
Mr. Bova, good morning.
Good morning, Your Honor. Good morning, Your Honors. May it please the Court, Christopher Bova on behalf of the Defendant Appellant Sex Offender Registry Board. Your Honor, this first case with respect to the Board is on reservation report from the Single Justice of Suffolk County, primarily to address the quantum of proof issue with respect to termination proceedings and reclassification proceedings initiated by an offender before the Board. With respect to the issue of quantum of proof, primarily under 972 and 383.16, this court has undergone a Matthews analysis and looked at the private interests, the risk of erroneous deprivation, the government interests, and then balancing those interests and making the final determination as to what that quantum of proof should be. In looking at the quantum of proof, we're looking at the importance of the factual undertaking, the weighing of the private interests, as well as the public interests at stake, as well as the risk of error and where that risk of error should be distributed throughout the parties. It's the Board's contention that the quantum of proof in these particular proceedings should be based at the clear and convincing standard of proof as outlined in DOE 383.16. There's a question as to...
Yeah, I'm perplexed why you changed, not you, why SORP changed its regulation after DOE 38316 in this regard to be clear and convincing when the DOE decision said that there must be clear and convincing evidence to find somebody a level 2 or level 3. And then you adopted that standard to say that for that subset of persons who seek reclassification, that they must show by clear and convincing evidence that they're not. What was it about DOE that you thought obligated you or caused you to do that?
At first blush, it may seem odd that the Board changed it, Your Honor, but I would suggest it's logically consistent, not only with the statute under 178G with respect to termination proceedings, but also with respect to the degree in which you want factual certainty of these decisions. In 383.16, what this court said was that it was very important to make sure that the risk of reoffense and the degree of danger was determined so that there was some import to that decision. I don't think once that decision is finally made, once you have that final classification, that the risk should change, that the quantum of proof should change, because at the time of final classification, it's very important that the decision maintains and is consistent throughout. So why the Board changed the quantum of proof in that instance? Because the Board, this court upped the ante with respect to the quantum of proof to make that initial decision. I think it's consistent to say that that decision is important and should be considered going forward.
But to be eligible, you can't even, under the regs, you can't even apply for a downward classification unless you have no new sexual offense, well, unless for 3 years you've remained, actually 5 years, you've remained offense-free, so you can't have any offenses that you've committed in the 5 years since your release from incarceration. You can't have any new sexual offenses, or at least none within 10 years, or there is a material change in medical circumstances. So you're dealing with a subset of persons who have not committed any offense, certainly not any sexual offense for many years, and because you can't even apply for 3 years after the original classification, virtually all of the persons right now who you are reviewing were found level 2 or level 3 by a preponderance of the evidence, not by clear and convincing evidence.
Obviously, the change in the statute occurring in 2013 with respect to level 2s and level 3s, but time in the community as well as age is important it's not outcome determinative in terms of whether or not an individual is going to be reclassified downward. So while those are factors that are necessary in order to undergo reclassification, those factors aren't necessarily the driving factors. There's certainly factors that should be continued. However, there are additional factors that the board must continue on during these reclassification hearings. Factors such as whether or not there's any type of treatment, factors of whether or not there's any type of stability, factors such as whether or not there's any successful completion of probation. So while time in the community is certainly important, and it certainly governs whether or not an individual can get before the board on reclassification, it's not the end-all, be-all. And simply because an individual has 5 years in the community, 7 years in the community, doesn't necessarily mean that his risk of reoffense and degree of danger is going to be reduced. As you look at the statute...
It's 5 years offense-free.
Correct, correct.
I mean, that's better than the alternative.
It certainly is better than the alternative, but just because an offender has 5 years offense-free in the community doesn't necessarily mean that his risk of reoffense and degree of danger is going to be reduced. It's one factor out of several that the hearing examiner must consider when making this ultimate determination.
They can't bring a reclassification for 3 years, is that right?
That's correct. It's
And where does that appear? Is that in the regulations?
That
or-
is within the regulation, Your Honor. Currently, the regulations were updated in 2016, so that would be under 1.31. And it specifically says that an offender has to be, it's 3 years after final classification when an offender can apply for reclassification downward.
I don't, go ahead.
No.
Go ahead.
Well, I was just going to, going back to the clear and convincing standard, assuming that's correct, why is it that the offender has to be should be the one to prove that by clear and convincing evidence that they're misclassified? Why shouldn't we use the standard we used in care and protection of Aaron?
Well, that bleeds into the second case that's on the docket today, the Noe case. I'm happy to address it here. When you're looking at the locus of proof, which party bears the actual burden, which is separate and distinct from the quantum, but when you look at the locus of proof, I think you need to look at the statute. I think that's the first place that the court should go in terms of the statute. Now, in these particular proceedings with respect to termination, you have to look to 178G, which specifically places the burden on the sex offender to prove that, by clear and convincing evidence, that they should be terminated of their obligations to register. The board maintains that the statute doesn't address offender-initiated downward reclassifications. That's taken care of in the regulations. Under the old regulations in 2013, that was under 1.37C. Under the new regulations, it's 1.31. Under the board's regulations, which I would submit has the force of law and should be given deference as a statute, the regulation specifically puts on the offender the burden to prove by clear and convincing evidence, and this is something that is before the court today, that they show a reduced risk of reoffense and degree of dangerous. Now, the first look is by the statute. The second, if the statute is silent, which the statute and the regulations are not silent in this instance, the second instance is to go to the ordinary default rule, and the default rule is the person who brings the suit, who initiates the proceedings, who seeks to change the status quo, that individual should bear the burden. With respect to the Superior Court's reliance on care and protection of Aaron...
I find it odd, though, that, I mean, so this court shifts the burden to clear and convincing evidence on the government to establish the standard, which suggests that we're imposing a greater burden on the government if you want to classify someone. Now, after 3 years, when they're entitled to get a reclassification decision, we're going to put the burden on the opposite side to establish by clear and convincing evidence. It just seems like it's flipping. It is flipping the burden of proof, but it also seems like it's flipping the logic of the prior case too.
I would respectfully disagree, Your Honor. I think it's important in terms of looking at the private interests in these cases. When you're dealing with an original classification, that is when an individual comes before the board, he's in unclassified status, a level 0 status, and he goes before the board for a final determination of that classification level. I think the court recognized in 383.16 the importance of that decision-making process. However, I would submit, and I argued this unavailingly in the Superior Court, that the private interests change on reclassification. And I think there's an important distinction here, because at the time of final classification, society's interests are now raised. Society's interests are now equal to, if not stronger than, the sex offenders. The court was concerned about overclassification during 383.16. You don't have that concern now because an individual has been finally classified. An individual has sought judicial review in Superior Court. An individual has sought appellate review. So the strength and confidence in that decision is overwhelming at that point in time.
But the decision has already taken place X amount of years before. And so when you're dealing with a reclassification, if the burden is on the registrant, then all the Sex Offender Registry Board has to do is say, okay, this was the situation back X amount of years ago. The privacy interest still remains. So shouldn't there be some burden now on the board to be able to say it should be the same classification?
I don't think so, Your Honor. And the reason why I say that is because you look at the private interests at stake at downward reclassification proceedings. First, throughout the 25 years that this court has been looking at this law, at no time has this court ever said that the interests at stake are fundamental. So I think that's very important, first off. Second of all, you have a final classification decision that has been reviewed by the courts and that the plaintiffs have been offered due process, extensive due process in this particular case. Thirdly, and this is important with respect to the In re Aaron comparison, you have to look at the type of proceedings at stake here. And these downward reclassification proceedings, they're rather informal. Offenders have the opportunity to come before the board. They have a chance to tell the board is what's new, what is going on with your life since your final classification. So you have a situation where they say, I'm working, I'm employed, I have housing, I've been taking sex offender treatment, I've been going to substance abuse treatment. And these issues are all coming forward.
But wouldn't that happen in a care and protection? The care and protection of Aaron, the mother, is moving, and she needs to show what's happened since the previous proceeding. So I don't know why they're not analogous in that sense.
The Superior Court relied heavily on care and protection of Aaron, and I would suggest there's 3 errors that the Superior Court committed with respect to care and protection of Aaron. The first, again, is the fundamental rights of a parent and the relationship they have with the child. In some of the case law that I've read, this court has stated that the fundamental interests of a parent raising their child could be actually more than the loss of liberty of that parent. So you have to take into consideration the fundamental rights in care and protection cases. That's not the case here. Secondly, in re Aaron, and I refer to In re Andrews, which was a case in 2007 that this court decided, and they specifically stated in that case that In re Aaron, the statute was silent as to the burden of persuasion. That's not the case here. The statute specifically states that the burden is on the offender. The regulation specifically states that the burden is on the offender. And finally, with respect to care and protection of Aaron, I think you have to look at the proceedings. I think in care and protection, as you look at that particular case, the Aaron case, that case relied on Santosky versus Kramer, the Supreme Court of the United States case. There are several things in that case which are very different than hearings before the board. You have a situation where the government is looking to terminate parental rights. You have a situation where the government is bringing in witnesses, sometimes expert witnesses, to attack and to boost their credibility in their proceedings. You have instances where they're cross-examining witnesses. You have instances where I apologize, I lost my train of thought, but there are several distinctions, and I outlined this in my brief, in that those cases regarding care and protection proceedings, regarding termination of parental rights, I would suggest that there are specific differences from these proceedings before the board.
Can I shift you to you got a minute left, I'm sure the chief is going to be generous, but the last issue, I'm trying to understand, so the third issue is that you're not giving any of these reclassification hearings and for years. I'm also understand you have a huge backlog driven by the change from preponderance to clear and convincing. What does this mean in terms? What are the practical realities of when you can hold these reclassification hearings, given the backlog there? Can you give us a little, they've made an argument that you're violating their due process rights by not giving them any of these hearings for long periods of time, and I'm trying to understand what kind of pressure you're under right now.
I would suggest that that argument is a little bit deceptive. And as I noted in the board's brief, the board was conducting these hearings in both 2014 and 2015, before 38316 came down. The board was conducting approximately 25% of its hearings in 2015 were to termination proceedings and offender-initiated reclassification proceedings. As I outlined in the board's brief, 38316 had a profound impact on how the board conducted its business because we had approximately 400 cases come back to the board. Then follow that up with respect to the Superior Court's decision in the no case. And so the board was faced with some tough decisions it had to make, and we focused on those individuals who were finally classified.
I'm not focusing on the past so much as how do we address that argument, given, I mean, how far are you in the backlog of these 400 cases, for example?
I see my light is red. If I may continue and answer the question. Thank you, Your Honor. The board is aware of the numbers at play here, and the board certainly wants to move forward and start conducting these hearings again. When the board pushed the no appeal.
I'm not criticizing, you don't know what the standard is. What I'm trying to understand, though, is going forward, say in 2 months you get a decision from this court telling you what the standard is.
We are actively, to answer your question in short, Your Honor, we are aware of the situation. We are actively in the process of designing procedures to implement as quickly and efficiently these cases as possible. We want these cases heard. It's the board who wrote this regulation. It's the board that gave the offenders the chance to seek downward reclassification 3 years after final classification. It's the board who wants these offenders to have the opportunity to come forward and reduce those classification levels if it's warranted. The board is aware of those numbers, and we're ready to take steps.
From what I understand, there's a statutory priority that these would have to come after the regular classifications, right? So is the
Correct.
Is the board relatively current? I'm just trying to understand what.
Thankfully, Your Honor, we have worked through the 38316 backlog. We only have a handful of cases left over from 38316. The board does understand the numbers. The board is seeking possible solutions to push these cases forward, to get these cases out. We want these cases heard. We're going to work as hard as possible to get these cases done.
If I could ask you a question with regard to that. If there were no regulation providing for a reclassification hearing after 3 years, would there be a constitutional obligation for you to hold such hearings?
I think thankfully, because the board wrote that regulation, we don't have to necessarily address that, but there could potentially be a due process issue if there was no regulation. But regardless, because the board was proactive in that, I don't think we necessarily have to concern ourselves with that.
Well, I'm following up. I'm looking to Justice Cipher's opinion in the Appeals Court 2012, where she writes that the downward classification procedure, quote, provides the sole mechanism for protection of an offender's constitutionally based rights where the passage of time has reduced the risk of dangerousness such that the Commonwealth's interest in disclosure is eroded, properly permitting him to obtain a lower classification level. That seems to say that there would be some constitutional obligation to provide that avenue.
I would agree it's at least opening the door to potentially questioning that issue, but thankfully, because the regulation was placed, I don't think the court necessarily had to go into it any deeper in terms of whether or not a constitutional issue occurred. But I would suggest that certainly that is an issue that the court could take up and look in with higher degree of circumference.
Is my memory incorrect? Didn't Judge Wilkins in the Superior Court address this issue?
Judge Wilkins addressed this issue with respect to constitutional issues in reference to whether a sex offender during offender-initiated downward reclassification proceedings was entitled to a adjudicatory hearing.
Right.
So he was looking at 38 Section 1 through 14, the Adjudicatory Procedure Act, and he garnered a lot of the information in his decision out of that.
And the board didn't appeal that decision, is that right?
The board did not appeal that because at that point in time, we felt that Judge Wilkins was correct in his decision that the offenders who brought forward reclassification motions before the board were entitled to evidentiary hearings of significance in that. I think with respect to the right to counsel, which we're going to get in the no matter, I would call your attention to Judge Wilkins' footnote 9, where he specifically stated that the fact that that offender in that case had an attorney was probably going to be the exception rather than the rule. So I think he did take into consideration some other factors, but primarily he was looking into whether or not they were entitled to an adjudicatory hearing.
And I guess going back to my previous question, if, I know this is not your position, okay, but if the position of the board were to be, we don't intend to hold reclassification hearings, or we intend to devote so few resources to it that for all practical purposes, there could be a 4, 5, 6 year delay in getting it, would there be any lawful, would that be unlawful?
I guess it's a question in terms of what specific time frame you're looking at, Your Honor, because
Well, I'm looking to you as to what you think. I mean, I guess the one question is, is there any obligation, legal obligation for you to hold hearings? And if the answer is yes, what is that obligation?
Well, assuming that there is no regulation, is that?
No, there is a regulation, but there also may be a constitutional overlay to it. But so I'm just trying to, I mean, if there is an obligation, I'm just trying to get it. I think you agree that if there is an obligation and you hold no hearings, there has to be a violation of that obligation. Yeah. So I'm trying to get a sense as to what you say is the extent of your lawful obligation to hold hearings, either pursuant to regulation or pursuant to the Constitution.
I think I understand Your Honor's question now. I think what you would have to look to is the literature, I would suggest, in terms of time and community, where they say that the risk of reoffense as one is offense-free in the community starts to decrease at 5 years. So maybe 5 years would be a good thumbnail rule for the court to look at as to whether or not an individual has to have their hearings every so often. Then it drops again after 10 years, and then after 15. That's what the research would say. So I would say a starting point, 5 years based upon the research, would be a particularly good time to review offenders' petitions. But in erring on the side of the offender, the regulations indicate that they have that opportunity every 3 years.
Okay, but my question is not so much when they should have the opportunity, because you've chosen 3 years, but what standard, if any, should be applied to your obligation to actually hold hearings in accordance with that regulation or in accordance with your constitutional obligation?
Well, I think ultimately you'd have to look at the due process concerns. You'd have to do a Matthews analysis and look at the private interest, the government interest, do a balancing act, and look at the risk of erroneous deprivation.
Okay, and what do you suggest that we do upon having done that analysis? I'm trying to figure out if there's any standard you're proposing to us that would be, that you think would be a fair and appropriate standard to impose.
Well, I think in terms of, I think you're getting at the timing issue in terms of when the board should be allowing these individuals time to conduct.
I'm just trying to get some, I guess let me go back.
And I apologize.
If you had come before us with a position that you're not taking, to say, we don't intend to ever hold those hearings, would you agree that you would that would be in violation of your obligation pursuant to the regulation?
Yes, if the board was prohibiting these individuals from having these hearings forever, then you would have to rely on the statute with respect to termination under 178G and the right to seek termination after 10 years from final classification. So I think 178G at that point in time would be a starting point for this court to look at if the board didn't have those regulation proceedings in place.
178G says what? About, it has a 10-year?
There's two parts of, I apologize, Ron, I didn't mean to cut you off, I apologize.
No, I was just following up on your point about that 178G sets a 10-year provision. What does that
Yeah,
provision
there's two
say?
portions of 178G. Essentially, individuals after 20 years can be relieved of their duties to register, provided that they haven't been convicted of such things as a sexually violent offense, provided that they haven't been convicted of a sex offense involving a child on separate occasions. And then as you work your way through that statute, about in the middle of that statute, you have a situation where an offender can bring to the board's attention and seek termination of his registration obligations within 10 years after he's been convicted, adjudicated of a sex offense, and has his probation or sentence expired, whichever is later. But that's the basic language of 178G. And so I would suggest that that would be the baseline that the court would have to look to. Obviously would have to apply the due process analysis to determine whether or not the 10-year provision regarding terminations would be a violation of due process. But I would suggest that in this particular case, the board has taken into consideration of that.
Let me just ask before you sit down, would you say that the board has an interest in making sure that all offenders are properly classified, whether that be upward or downward? If somebody comes before you, the board has an interest in making sure that that person is properly classified. Is that fair?
That is very fair, Your Honor. The board has an interest in making sure that their classification levels are current, are accurate, and they're not overclassified, not underclassified. I would suggest that at the point of original final classification, that is the time where we have full confidence in that classification level. And as you move past to reclassification, at that point in time, and this is why the burden is on the offender, is to show that his level has decreased. And as I read some of the case law, it says that over-inclusiveness is not necessarily constitutional impermissible. So the board, in going by its prioritization, authorization under the statute, has to look at these individuals and make a determination of where we're going to classify these individuals and where is there some over-inclusiveness is constitutionally permissible. Where is it okay to go forward and put our resources to make sure that these cases are getting done on a consistent basis. So there is an interest with respect to current risk level, but some degree of over-inclusiveness is constitutionally permissible.
All right, thank you.
Thank you very much, Your Honors. Thank you. Thank you for the time.
Mr. Tannen, good morning.
Morning, Your Honors. Eric Tennant, in this case, on behalf of John Doe and all the other plaintiffs. With me is Kate Frame, who will be arguing the second case. I want to begin sort of picking up where you left off with the questions to make something really clear, if it's not already, about our clients, about our plaintiffs. These are persons who already qualify for reclassification and termination, meaning they have already been out for the 3 years or the 5 years or the 10 years and have applied for the hearing. And having applied for that hearing, they haven't gotten one. And at this rate, won't get one for another 10 years. So I think the real question
But
isn't...
why is it they're not going to get one for 10 years? Because I can't, I understand they've been digging through the backlog, which, you know, was required once we changed the standards. But why would you say they wouldn't get one for 10 years?
Because the backlog existed before 380316.
Well, how many people are we talking about, from the record, if you know?
So on the record that we have, it was somewhere around 700 at the time we filed our brief.
700 people seeking the reclassification.
Or termination, yes. Essentially, they have filed an application and had yet to have given a hearing or decision on that. I think it's grown since then. There's a motion before the court to expand the record. I think it was included in one of the amicus too. We're at, up to about 1,000 now. But we go in our brief, we have the public records request to go back. You know, you can see it by year, and this backlog began in 2014. They only held 58 reclassification hearings back then. So if you take a pre-backlog pace.
So the pace before the change to clear and convincing, the pace they were deciding these cases was what, 58 a year?
In 2014, there were 58 reclassification hearings. In 2015, there were 73, so that's the year that 380316 came out, so a little overlap there. I heard Mr. Bova say something like they were dealing with 25% of the cases. I don't know if that's accurate, but I think that's a good sense of it, which is if you have a backlog in the hundreds and you're dealing with, you know, 58, 73, whatever it is, it's going to take you a long time to work through it. And so we've done the math, and at this rate, even if you go back to the pre-backlog rate,
So what are,
that's where the 10 years comes
so
from.
as a practical matter, because they also has a statutory priority, right? Or do you disagree with the statutory priority point?
You know, when I read the statutory priority, that is a statutory priority of initial classifications. It's not, it doesn't talk about how they are to deal with petitions for reclassification or termination. I think that priority, if I understand the history correctly, was initially in the statute because they were starting this process, and they were saying, as we're starting this process, prioritize this. That's remained in the statute, and I think whenever there's a backlog, they go to that to figure out how to get through their backlog. But that priority, I don't believe, talks about this. This is a separate issue. This is, I strongly believe, a constitutional issue because it is the ability to be reclassified, the ability to have your level reevaluated over time that makes this scheme constitutional. If it did not exist, going to some of the Chief Justice's questions, if you did not have this ability, it would not be a constitutional scheme because the scheme is so carefully balanced between the private interest and the public interest. And it's only when the board can justify the dissemination on the internet or other things because of the person's risk that they're allowed to do it. That this court says you can do internet dissemination, you can do active dissemination because you have accurately assessed this person's risk within the parameters we have set. Once that is no longer accurate, that balance shifts, and you should no longer be able to disseminate or subject someone to some of those risks. And so the way the board knows that the balance has shifted is through this process of someone being able to come to the board and say, things have changed. By your own regulations, you recognize that over time risk declines, over 5 years, over 10 years. You recognize that the older I get, the less likely I am to reoffend. And so I'm here telling you, I'm now at that point where things have changed, and because of that, you no longer should be able to disseminate my information or subject me to all these problems. And so when you take away the ability for the person, for the registrant to come forward and have that conversation with SORB, I believe that makes this scheme unconstitutional. So this gets back to Justice Seifer's quote that you read, and that's certainly not the only quote. This is repeated in these cases over and over, that the ability to have access to reclassification and termination is so vital.
What is your remedy here? So, because you're asking for right to counsel, right to hearings, very expeditious. I'm just trying to,
Sure.
I mean, because
I promise I will answer that question. I just want to give you a little context.
Okay.
The no case is about the right to counsel, but yes, that's part of all
right,
this.
but it's all, this is all one big ball of wax.
And to be clear, our case, what prompted it was this backlog. It's right now you're just deciding whether or not you should dismiss the case or whether we should be sent back to the single justice to figure out what the remedy is.
I'm looking for what you think
Sure.
a reasonable remedy is, because they can't magically classify 700 or 900 people.
I agree. I just wanted to give you that context.
No, you're doing just what you're supposed to do, but I'm trying to come up, we have to come up with a practical rule.
So
I'd
I
like-
think if we went back to the single justice, we would propose a couple things.
Who was the single justice? I forgot.
It was Justice Gantz.
Okay.
So
Maybe we
I
should
speak
decide
right
this
to-
here then.
Maybe I should, if we go back to you, Justice Gantz, this is what I would propose. The first thing we would propose is, let's figure out what the appropriate amount of time is. That is, how long you should have to have a hearing and or decision. Because at the current rate, I think everyone can agree, it is way too long and unconstitutional.
How long do these generally take? Each one of these, these individual ones, are they full trials? Are they mini trials? How long do they take?
Let me answer it this way to give you the other thing I would propose, because I think one of the reasons this problem arose is after Judge Wilkins' decision saying that you have a right to a hearing in a reclassification hearing, SORB amended the regulations to say, okay, we're going to give everyone a hearing in reclassification petitions. The problem was, I think what Judge Wilkins was really saying is, if it's contested, if you don't agree that this person should be lowered, well, then he has a right to a hearing where you can fight about it, and then you can get 30A review. The real thing is, if it's not contested, you don't need a hearing. And I think that's one of the big problems is that SORB has not created a process in which they might agree. If they look at their own regulations and say, I see you're 82 years old and you've been offense-free for 10 years, we don't need a hearing, we agree. You're asking for a termination, you got it, or you're a level 3 and you've been out for 10 years, we agree, you should be a level 2. If SORB created a process in which we didn't have to have a hearing when they agreed, sort of a mini summary judgment, that would clear a lot of it. That's one of the things I think we would ask Justice Gantz if we get back there. That would help clear it, and then we would figure out timing and maybe set up a process in which this can be expedited in some way. Right now, the way it works is that they are hearings very much in the same way that you have the initial classification hearings, and I think that is wholly appropriate when it is contested. But I think that's really the only time that is necessary, and if you got rid of that, or if SORB sort of untied themselves from this idea that everything has to be contested, you could work through this. So I think between those two things, we could really provide a
They
remedy.
just redid, so they've dug through the 700 cases that we sent back to them, right? Why didn't that work? Why would a similar approach to solving this problem not work?
I'm sorry, you're talking about the remand from the 380?
Oh, yeah, we just made them redo how many cases?
I think it was 400 cases.
So, and how long did that take?
Based on what I heard, he said they're just getting through it right now. So
I assume you're on the opposite side of a lot of those, so.
I am on the opposite side of a lot of them. But what they did to undo that backlog was basically just restart the process and the hearing process for all these persons, as they should.
So
So they were doing at the same time.
why should we dictate a remedy that, why should we assume that wouldn't work again this time?
Because here's the problem. So for persons who have initial classifications, to be quite blunt, they're in no hurry. That is, they have not been classified. They don't have the burdens of registration upon them. If it takes SORB a year or 2 years or 3 years to get through that backlog, to reach that hearing, that person, the registrant is okay. He's not burdened by it.
Public interest is different, though, at that point, isn't it?
For which one?
For initials. That's why the statute says do the initials first.
The public interest, I think, is the same for all of it, which is, if there is someone who is a high risk, we want to know about them. And if there's someone who isn't,
Right, and that's why the legislature could reasonably say, let's do the initial classifications first.
So again, I go back to that point in the statute. I think that was just a priority of, among the people eligible for initial classifications, who should we
Right,
prioritize?
I get that's your interpretation
Okay.
of why the legislature did that.
All right, so the question was, why not just let SORB work through the backlog for these reclassification hearings, the same way we let them work through these remands of initial classifications? And my response is because all the balances, the public and private interests, I think are different for reclass hearings. There's a much stronger private interest in a reclass hearing for someone who has been classified and subject to all of the burdens for all of the 10 years, the 50, whatever it is, and is trying to have that hearing and they're being put off, versus someone who is still waiting for the initial classification and their interest in being initially classified is not as strong.
I have a different question, but I don't know if
Sure.
you finished Justice Kafka's.
I just have one last one, which is, and I can't remember the posture when we sent back all the cases to be retried. Were those people without classification, or were they sort of in the same kind of presumptive state that this group is, which is that SORB liked their original classification and now had to redo it all, so they had no incentive there to push them forward? Or did we say that they had no classification, therefore SORB had to move very quickly? I can't remember the posture of
My understanding,
Right.
So take it for what it is.
Yeah, no.
These were persons who had an initial classification hearing, weren't happy with the results, and were in the process of appealing it. And so there was about 400 cases, either at that initial stage or in Superior Court or maybe in the appeals court, that were pending, review of that initial classification when this court came down with its decision. So those cases then reverted back to the pre-initial classification status.
Okay, so that you say the incentive was different because they were pre-initial.
Not the incentive, the balances, the interest of the registrants being.
You're saying that, your point was that SORB doesn't have the same incentive here because they like the classification and they don't want to reclassify, or they.
That's part of it.
But I'm trying to see whether the same incentive was
Right.
there last time, because SORB had classified everyone at preponderance, and this court said, no, you got to do it at clear and convincing evidence.
I think part of it, right, SORB wanted to hurry, correctly so, I don't take issue with that, to get these initial classifications decided again. And in our case, they already have something in place, but the other interest is the private interest for the registrants who were initially classified. They were in no hurry, but for our plaintiffs, for where we are, they have been classified for all this time.
Yeah, the question I had is, and we may agree with you that it makes no sense to have the plaintiff bear the burden of proof. How do we distinguish the Ronald R. case? And I know that dealt with the juvenile context, right, on the need not to register. But in that case, the burden of proof, we said, falls on the person who brings the claim, and we reverted back. So how do we get around that?
All the cases I reviewed, that is not one I reread recently, but I am familiar with it, and I believe I understand the posture. That was a case where a juvenile
Right.
was asking to be relieved of registration upon a finding of delinquency or guilt, whatever it was at the time.
And we said the burden of proof falls on the juvenile in that case. And then what the SORB also says is that this is unlike the fundamental right for keeping your child.
So I think that's, first of all, that is a statute, that's in the statute that puts the burden on, it's not just the juvenile, whoever seeking relief from registration at the criminal stage. I think the other issue is, the reason, my take on it, so not having reread the case, is that it's okay to place the burden on the person at that stage, because even if the judge says you have to register, they now get put into the regular due process protections of a classification scheme. And so
Right,
it's
what
just,
SORB argues is, and I assume you certainly disagree with it, is that someone who was initially classified had the due process protections.
Right.
And then they have a lesser interest.
I see, okay.
Right.
In that respect, I mean, we do speak to that in the brief, and I will go back to this idea that this is a big disagreement. They seem to believe that once you've been classified, your interest somehow goes down. And I take the total opposite view, which is once you've been classified, the longer you are subject to the registration scheme, and the longer you are doing the things that everyone agrees, including the board, shows you are less of a risk, meaning offense-free, aging, whatever it may be, the more of an interest the registrant has to having ability to be accessed, because they are now being subjected to whatever levels of dissemination, whatever harms come from that initial classification, that the day after and the day after that, every day that passes, they become less and less of a risk.
So you would distinguish Ronald R. by when the due process rights are implicated?
When
That due process rights are implicated
Right,
at every stage?
Because it's at the very beginning, knowing that he's still going to have a chance to challenge it and get the full panoply of those rights that someone gets at a registration an initial registration hearing. But once you have been registered, again, every day you spend in the community, even according to their own regulations, according to all the science, you become less of a risk. And if you continue to become less of a risk in ways we all agree, how can that initial classification continue to have validity? And so you have to have the ability to have that reexamined to be challenged.
And you say as time goes on, without reoffense, that privacy interest and liberty interest turns into a burden of proof on SORB.
Yes,
For the
even
same
more so.
reasons, for the same reasons.
Meaning, if it's there at the initial classification hearing, right? This court's already said, we put it on them at the initial classification hearing because of the balances you've already found. If the privacy interest gets only greater the longer you're out, then of course that burden should remain on them. It's sort of the analogy I use, I know it's not perfect, but it's like in a criminal case, the more evidence of innocence arises, we're going to put the burden on you to prove you're innocent. It's sort of crazy to think the more information we have that you're less of a risk, we're going to then put the burden on you as opposed to.
Although that makes it easier. I mean, it would make it easier on the registrant if there's an increased lack of risk emerging. It's easier to meet any burden.
It would make it easier because only in the sense that, yes, they have more information they can say, but it would make it harder in the sense that SORB doesn't have to do anything. And so the registrant would have to come forward. Maybe he has counsel, maybe he doesn't. I don't know what you're going to say in the next case. Maybe he's read the regulations, maybe he hasn't. I mean, the point of putting it on the board is I'll go back to 380316, which is you've already decided that it's unfair to put the risk on the registrant in these situations, the risk of an erroneous classification.
And you believe that the government's interests are protected because they establish the eligibility standards?
That's one of the ways in which they're established. We're not here saying that we're not here disputing what it takes to qualify for reclassification or termination, the 3-year, the 5-year, whatever it is. You put that in place, so we take that to be, okay, that's our burden of production, and we have to at least meet that much. This is a case where everyone's met that. And that is enough to then say, okay, you've come forward, you've shown us by our own regulations that you've been out, you're old, whatever it is, so now we have to justify keeping you at whatever level we want to keep you at.
But if we can step back, as important as the burden of proof is, it doesn't do any good if we're not having the hearings.
That's why I wanted to, yes.
So if we can shift so that we can get to that point for a moment. So there's a due process argument, maybe even a superintendent's argument, but doesn't the statute require that the hearing be in a reasonable time, the 178L3 statute?
There is language in there, and just to be totally clear, to make sure we're all on the same page, the statute says, talks about the right to termination and a hearing to be done in a reasonable time. The regulations, that has been interpreted by courts as I'm sorry, that's termination. The statute, the regulations talk about a reclassification. They used to have the reasonable time language. It's now changed to as soon as practical, I think. So there is some guidance from the statute, but I think the most compelling argument is that due process obviously has to require some reasonable amount of time. Otherwise, you're stuck where you are, where the board is saying, we don't have to do it, or we can do it whenever we want. And with a backlog 10 years later, maybe they get around to some of these.
I'm going to ask you the same question I asked your brother as to what you suggest the standard is. I mean, I'm mindful that, at least when I left the Superior Court with regard to SDP cases, concerning those persons who were by statute entitled each year to a review, we were backed up, and you would probably not get it for 3 or 4 years. So this issue of being backed up to provide rights entitled by statute or by regulation is not unique to SORB, but we're not generally asked to be establishing some standard to address that. And what do you suggest we do?
Meaning, what do I think is a reasonable amount of time?
What do you suggest is the standard that we apply? Is it your view that we should be putting time limits? Is it your view that we should establish a standard? What are you suggesting that we do?
I think, not to deflect, but I think that's something that if we go back in the single justice session, we can hash out when we have a sense of how many cases are we talking about, what sort of manpower do we have. I think that there are some time gates that you can look at to say, well, this is too much. So for example, at its current pace, 10 years, I think everyone would agree is too much for a hearing and a decision. If you look at SORB's own regulations, if you're allowed to apply every 3 years for reclassification, how in the world then would it be reasonable to take longer than 3 years to decide that? So now you have another time gate that says, well, at least this much is unreasonable. And I think you can start working backwards from there, once we can kind of figure out what parameters we're talking about, how much.
So let me go back. They moved to dismiss, and
Correct.
the matter before us is whether we should allow the motion to dismiss.
Right.
If we were to deny the motion to dismiss, what are we deciding?
We are deciding, I think we're deciding two things. The first thing is how long should you have? How long do you think you can do it in, and is that good enough? And what conditions or procedures can we set up to help expedite it to get you to that point if you can't figure out a way to do it on your own?
Is that something that, I'm referring to what the full court is deciding as
Today.
opposed to what the single justice would be deciding if the motion to dismiss were denied. The issue before the full court is, do we allow their motion to dismiss?
Correct.
You want us to say, no, we should deny it.
Correct.
And what I'm asking you is in terms of, if we were to deny it, what would we need to decide?
I see.
In order to deny it, and then so basically, do you think must this court decide versus what is to be left for the single justice?
I believe all this court has to decide, and a motion to dismiss is whether we've stated a claim. And I think we have stated a claim that the current state of affairs in terms of how long our plaintiffs have actually been waiting, in addition to how long you can anticipate they're going to wait, is if that didn't change, that would violate the Constitution, it would violate the statute, it would violate the regulation. We have essentially stated that claim. Once you acknowledge that, their motion to dismiss is denied, and now we go back to litigate that, like you would in a regular case. We have stated a claim that the length of time is unreasonable under any, under anything that allows for the.
But you seem to be calling for something more. I mean, we normally would, issue a decision, and then we don't put you in, we don't put SORB into receivership. This isn't the, the MWRA's cleanup of the harbor. I mean, I'm trying to understand it's the second part that I'm particularly curious that you're expecting to happen. So you win the motion to dismiss, and then the single justice puts them in receivership? I'm confused.
I was saying that actually in an attempt to be cautious, meaning once we establish, we've stated a claim, once we establish how long it should take, then SORB can say, we can do it or not.
But their standard right now is this practical standard. I take it that's not substantive and meaningful to you, and it may not be, but I don't understand this second part that's going to happen. We're going to issue a decision, then you're going to go back to the single justice to look at the scope of the problem and put in sort of,
I think,
what are you looking for? I'm curious, because that's not how we normally do our business.
I think in the first instance, all we're looking for is to establish what's too long and what's not too long.
Mm-hmm.
Once we have that, SORB can say, okay, we can comply with that. We've come up with a way to get to that point. And if they cannot get to that point, then we can look for alternatives to relief. We had a motion for a preliminary injunction. Maybe we litigate a longer injunction if they can't have the resources to do it in the time they need. So I was saying that as cautionary, which is we will establish how long they have to do it. They will tell us if they can do it. We can litigate that, and if they can't, then we can set up sort of an injunctive framework.
My understanding what SORB is saying is that if they lose this case, well, either way, there's going to be a standard by this court on what happens, the clear and convincing or either direction.
Sure.
Then they're going to go back and do their work. They're not going to agree. They're not going to have a set time frame because they don't know how many of these are going to be consensual and how many not. Then we're going to have, in my understanding, then you bring another case. It's not like this case keeps going, or are you asking for this case to be some kind of Annie Dukem type of remedy? I'm just trying to understand what you're asking for.
Sure, I don't think we're there yet. Among, the easiest thing we're asking for, let's put it that way, is declaratory judgment. It's a declaration of how long is too long. What do they need to do? That's the easiest thing we're asking for. Once we have that, once there is a judgment.
That's not so easy. I mean, determining the speed in which an administrative agency does its business is not something straightforward, is it?
It should be, because if we don't have a declaration saying that, then we're at the point where the current state of affairs is clearly unconstitutional. The 10-year waiting 10 years to get through the backlog at the rate they normally do it is clearly unconstitutional. So it's not easy to draw lines, but a line has to be drawn at some point. That's what courts do. That's what judges do. And someone will have to draw a line and say, okay, we're calling this the line. It's not what you have right now. Maybe we're not totally happy with it, but this is the line. You cannot pass this line because at this point it is unreasonable.
But it is pretty complicated. I mean, we're dealing with an executive branch agency and maybe a mandamus situation. This is not easy.
I'm not saying it is. That's why you guys are where you are, because that's what judges do. That's what these controversies require. They require line drawing sometimes. This requires line drawing. It requires a clear declaration that the current state of affairs is untenable. And if we know that, then that means we know there's a line somewhere. Let's figure out where it is.
No, go ahead. Go ahead.
I was just going to say, for instance, the line's 3 years, just for instance. Do you have a sense of how many of the number of plaintiffs have been waiting for over 3 years for their
For our
hearing?
own personal 20-some-odd, actually I don't. It's a good amount. I mean, they were anywhere waiting from 1, 2, 3, or 4 years. we don't have the stats for all 1,000.
Okay.
17 I'm being told 17 of our plaintiffs have been waiting at least 3 years, but unfortunately, you'd have to ask SORB what the total numbers are.
So let me just ask you, going back to what you might propose or what a proper remedy or structure could look like, if a petitioner petitions for reclassification, before there's a hearing, or would there be any threshold level for the petitioner to meet to show change other than time?
It's what exists.
What exists, which is what?
Which is, you have to have been in the community offense-free for 3 years.
Yeah.
The first time you're able to strike that. You have to have been 5 years offense-free from
Okay.
whenever you were released from custody or supervision for the first time. After that, you're entitled to apply every 3 years.
Right.
So presumably, when you're applying, you're saying, okay, I met that 5-year threshold, or
Right.
it's been 3 years since I was last classified. So that's what gets you through
So
the
there's
door.
nothing other than that?
And offense-free, right? So
And offense-free, I
Right.
mean, not to minimize that,
Right.
but I'm just thinking about the initial reach or the application, and is there a threshold in it other than, since we're talking about the burden of proof?
Sure. That gets,
Initial threshold there, because time alone and offense-free alone are not the end of it.
it's not. That gets you through the door. If you look at SORB's regulations, you could easily have other things that would make it easy for them to decide. They themselves recognize age, for example. If you're over the age of 60, it would be very easy for them to couple your age plus how long you've been out and say, yeah, you probably merit it. Just because you're only applying at this point doesn't mean you may not have been offense-free for longer. We have
Right.
people who have been in the community 10, 15, 20
I guess I'm wondering, is
years.
there a triage that needs to be done within the applicants?
I think there is. I think they're capable of doing it. It's not necessarily in the
Sequence.
in the initial
Yeah.
petitioning stage, but I think SORB is capable of doing it based on what they themselves
And
recognize.
and there's no requirement that anywhere that they process these in the order in which they're filed?
I don't know of one.
All right, thank you.
Thank you, Your Honor.